Hotep, I am the Amen Osiris, the one and only undisputed God of law. We are www.deceptionstoppers.com, America's only child support education service. I am not a lawyer. This is not a law firm. I do not advocate that you don't support your human offspring. I simply advocate that you made them in private, take care of them in private. Today, we're going to talk about rights. And this is why knowledge is important. All right, just because you go and read something, that's one thing. But to go and confirm, reading is fun to mental. It's not fundamental. It is fun to the mental. All right. And today we're going to discuss the fact that women and children, okay, do not have a right to child support, no matter who lies to them and tells them that they do. Okay. And I'm going to give you a small dissertation on this. And if you wish to learn more, well, you can schedule an appointment at deceptionstoppers.com and we will enlighten you. All right. So now I'm going to do East Coast and I'm going to do West Coast. All right. This is New Jersey's child support website. Okay. And down here, it clearly states, remember, your child has the right to support and you have the right to this help. Now we're going to go to West Coast, California. All children have the right to be supported by both parents. Okay. Now, we're going to go here to Rights Without Remedies. Okay. And it says here, the committee believes that all children have the right to receive support from their fathers. The committee bill, like the identical provisions passed by the Senate, H.R. 3153, last year, is designed to help children attain this right, including the right to have their fathers identified so that support can be obtained. Okay. Now, gentlemen and ladies, okay, let's look at let's look at what a right is. Okay. You were born with rights. Okay. Everyone has them. Well, you're supposed to have them. These corporations that you're dealing with, they violate your rights all the time. Okay, but everyone has a right. These are natural rights. All men are born equal, free. All men are by nature equal, free, and independent. Okay, and you'll notice, and no disrespect to the ladies, the Constitution clearly states man. It does not say woman or children. Okay, men have rights. Women didn't get rights till like the 1930s. Okay, and now the shit's off the hook because if you look in the Bible, in the Christian Bible, it says women. God saw that man was alone, and He created woman from man's rib. All right, and He created woman to help man. That is her only purpose on this planet. And again, sisters, no disrespect, but that's the law. Okay, that is natural law. All right, on this planet, you had no rights. All right, the only rights you had was to serve man. That is it. That is why, according to what they swear their oath upon, is written, okay, and says that look, man was created from the earth, woman was created from man's rib. Okay, that's why you have a floating rib. I believe the floating rib is on the left side because there's one rib missing. But this is not a lesson in physics. Okay, the problem here is the committee, whoever that is. Well, that's Congress. They believed that all children have the right to support. All right, just because you believe in something does not make it true. Children believe in Santa Claus. They believe in the Easter Bunny. They believe in the Tooth Fairy. People believe in Jesus and all this other stuff. All these beliefs. Okay, but right smack dab in the word, middle of the word belief is lie. Okay, really look up that word. Okay, so what we're going to do is we're going to look up the word rights. Okay, and we're going to go to Black's Laws. Okay, we're going to go to the Bible, the Biblios. All right, and this is the definition of a right. And I'm going to go down here, and I'm just going to read it from here in the green. Or the complex of underlying moral principles which impart the character of justice to all positive law. Let's go down here. And existing I always get this word messed up. Antecedently to their recognition by positive law. Okay. Now, child support is under what? Title 42 of the Social Security Act. Was Title 42 of the Social Security Act ever enacted into positive law? No, it was not. Okay. The distinction is legally significant. Non-positive law titles are prima facie evidence of law, but non-positive law titles constitute legal evidence of the law in all federal courts, positive law titles, okay? So a non-positive law title, such as Title 42, okay, it doesn't apply to all people. Positive law applies to all people, okay? Non-positive law titles are Title 42. They only apply to non-custodial custodial payrents, and persons. Another non-positive law title will be Title 26, which are the IRS codes, which only apply to who? A taxpayer. All right, you must voluntarily and by contract. The only way you can become a taxpayer or a non-custodial payrent is by contract. Okay, you are not required to pay taxes in this country, and you're not required to pay child support in this country. Okay, so that's number one. So here's the problem: if these corporations are stating that people have a right to child support, that is a bold-faced lie, and it is a violation of, 15 USC subsection 52, which is dissemination of false advertisement. That is actually a crime. Okay. Now, the other thing I want you to look at is this. Okay. Think about it like this. If women and children have a right to child support, okay, why do they have to fill out an application and pay $25 application fee? And why do they have to pay, the women, of course, why do they have to pay a $50 annual user fee? That is a very good question. Okay. Therefore, you have to learn to start looking at the case laws, and you have to learn how to start tearing this garbage down. Now, if women had a right to receive child support, then why does the child support clearly tell them we don't represent you and we are not your attorney and you are not our client? Okay? They provide services on behalf of the county, not on behalf of the children. Okay? As you know, all right, we'll go back here to the rights without remedies. Look, the 11th Circuit held that Title 4D does not create enforceable rights on behalf of needy families with children because they are not the intended beneficiaries of the statute. Title 4D was intended to benefit the public treasury and taxpayers. Okay? Public treasury pays the judges and all corporate, I hate saying this word, state workers. All right, it pays all their salaries and pensions. That means you're paying their salaries and pensions when they collect child support from your dumb ass. All right, nothing personal. So we're going to look at a case law, and the case law we're going to look at is called Mason versus Bradley. What I had to do, I had to copy it and paste it, and I wanted to show you some things here. Okay, and here it is, Mason versus Bradley. This is from Illinois. Okay, and you've heard me quote this before, but what I'm going to do is I'm going to tear it down a little bit more. Okay, and what you have is Anna Mason. Okay, look, on her behalf and as next friend of Ramisha Mason and Charles Mason plaintiff. These were her children. Okay, so in other words, next friend, look at this. I want you to see this. As next friend, you have the right, all right, to go into, let's say, if one of my siblings got into trouble, I could represent them as next friend because they are incompetent. Now it says, well, they have to be children, but if you have no idea what a child is and the age of majority is, don't bang your head against the wall. If you need to dig into that a little bit more. All right, but under next friend, I could represent someone who cannot represent themselves, and I don't need to be a lawyer. That would be a lawyer, in fact, but horse of another color. All right, and we're going to scroll down here. This is the United States District Court, all right, of Illinois. All right, order and the facts. Check this out. The lawsuit stems from plaintiff Anna Mason, this lawsuit stems from plaintiff Anna Mason's allegedly unsuccessful effort to spur the Illinois Department of Public Aid and the Cook County State's Attorney's Office to obtain child support from Mason's former husband. So in other words, she sued them because they didn't get her child support. Okay? And you're going to learn here today that this is why these women do not have a right to child support. And I want you to pay attention to the wording. Okay? Again, if you had a right to child support, okay, let's say you got arrested and they read your Miranda rights. You have the right to remain silent. Anything you say can and will be used against you, yada, yada, yada. Okay, do you have to pay an application fee for those rights? No, you do not. There's a $35 application fee for child support. Okay. Do you have to pay an annual user fee in order to exercise those rights? No, you do not. But in child support, you have to pay a $35 application fee, or you have, and excuse me, not or, and you have to pay I believe it's a $50 annual user fee. Right? You do the math on that. Okay. So the court basically, and I did the highlighted sections because I'm not gonna waste my time going into all that. Title 4D program in Illinois is overseen by the Child Support Enforcement Division. All right. The Child Support Enforcement the Child Support Enforcement Division is the what? The 42 USC 654-3 single and separate unit. All right. It's single, alone. It is separate, apart, and by itself. It is not a state agency. You notice it doesn't say, all right, the state's child support enforcement division. All right, there is no state child support enforcement agency. It is a federal agency operating in the state. It is a foreign corporation to the state. All right. Federal regulations require that prior to October 1, 1990, attempts to locate absent parents must have been made within 60 days of an application for such services. Here it is right here, gentlemen. So you fill out an application for child support services. Okay. Okay. That's no different than filling out an application for a job. Do you have a right to be hired by a corporation when you fill out the application? No, you do not. If that was the case, we could sue, all right, when we filled out an application for a job and didn't get the job. It is the same fucking thing. Okay? And you'll notice throughout here it says determine that such services. What is a service? A service is something that is offered. Okay? Now, down here in the black, continued federal funding of states' FTC program requires substantial compliance with the regulations, which is defined as 75% compliance in cases audited by the Federal Department of Health and Human Services. Federal, that's corporate. So in other words, this is their quota, and they raised this quota from 75% to 90%. Okay, you can find that in the Federal Manual, Child Support, Section 8. Let's see. Those payments are conditioned upon Mason's assignment of her child support rights to IDPA. Now, here's the thing, and I want to highlight this in red. How can you assign a right that you do not have? Okay? You don't have a right to child support. So how can you assign rights to child support? What this means is when these women go down and they beg for welfare, they apply for it. Apply means to beg. Okay? They're applying for a service. Okay? And again, just because you apply for something does not give you the right to it. All right? You can apply for a job. You can apply for Social Security. You can apply for whatever you want. No one is required to answer your application. You don't have a right to it. All right? Mason went to the child support office to request services. Okay? She applied for services. Okay? She begged, excuse me, she begged for services. That's all she did. No one is required. Look, guess what? I get people all the time. Yeah, man, I wanna hire you and use your services. All right, and there's actually some people I actually turn down. All right, depending on their situation. Okay, but you can't turn around and sue me because I'm not going to help you sue the child support agency. You don't have standing. All right, and we're going to get to that. All right, and I've talked about this before. Okay, now Mason filed the present lawsuit, June 19, 1991, asserting two claims. Count one asserts an action directly under Title 4D for the defendant's alleged failure to follow the requirements of that state and the allegedly resultant emotional distress and financial hardship Mason has suffered. Okay, guess what? All right. If you can't find a job, if you apply for a job and they don't hire you, is that going to cause you uh, emotional distress and financial hardship? Hardship? Yes, it could. All right, because if you don't work, you ain't got no money, you can't pay your bills, you're going to live on the street. Can you sue for it? No, you cannot. Count two asserts that Mason's 14th Amendment due process rights were violated by the defendants. Failure to provide the defendants for failure to provide her with child support services to which she is entitled under federal law and Illinois public code, yada, yada, yada. Okay, you are not entitled to anything under federal law. Okay, look, entitled to under federal law. Okay, again, You are not entitled to, if you got to apply for something, if you have to beg for something, that means you're not entitled to it. If somebody decides you to give you something after you beg for it, that's one thing, but you're not entitled to it. You're not entitled to the job at IBM. You're not entitled to the job at Apple or Microsoft. If you meet the qualifications and they want you, and after the interview you impress them, then they hire you. Okay? Try it out. Go apply for a job, right? And then don't get the job and turn around and try to sue them and see what happens to you. Same thing that happened to this broad right here. Okay. Now, what they did, they told her Mason lacks standing and her complaint should therefore be dismissed under Rule 12b1 for lack of subject matter jurisdiction. They put in a motion to dismiss, arguing that Title 4D creates neither a private right of action nor rights actionable under 42 U.S.C. 1983. Okay? And they were 100% correct. Okay? Now we're going to go down. The court therefore turns first to the jurisdictional standing issue. Federal jurisdiction power is limited under Article 3 of the Constitution to adjudication of a case and controversies. Okay? And I'm not going to go through the case laws. That limitation includes a requirement that a plaintiff have standing to bring the action, which in turn requires that the plaintiff personally has suffered some actual or threatened injury. Are you suffering an action or an injury if you apply for a job or a service and that service or that job is denied? No, you are not. You're not entitled to it. Because if that was the case, if you were entitled to something, I'm entitled. We're all entitled to the right to life, liberty, and happiness. We don't have to put in no application for that. Okay? Analysis of a party standing is gauged by the specific common law, statutory, or constitutional claims that a party presents. Okay? Where does it list in the Constitution that you have a right to get hired by IBM or you have a right to receive service from any private corporation? Okay? If you call Stanley Steamer and say, well, I need you guys to come out and clean my carpets, I want your service. Sorry, man, we're not going to offer you our services. Can you go and sue them? No, you cannot. Okay? In order to have standing, there's two requirements. One, a violation of a constitutional right. Okay. Number two, a personal injury. There's no personal injury or violation of a right when someone denies you a service or a job. Okay. All right. The claims are based on statutorily created rights. Number one, all right, you got constitutional rights. Statutory, there's no such thing as a statute. Statutes are not law. They have the force of law and require your consent. The standing question is whether the statutory provision on which the claim rests properly can be understood as granting persons in the plaintiff's position a right to judicial relief. Moreover, the plaintiff must have suffered or be about to suffer a demonstrable, particularized injury, which is fairly traceable to the defendant's alleged conduct. Okay, and will show that the requested relief will likely redress the alleged injury. Okay, read the Allen case. Standing for Mason on count one, her direct claim under 4D therefore turns on whether that the statute created an expression or implied private right of action. A private right of action can only be created if the federal statute in question creates enforceable rights. All right, and I've read you this case, Pennhurst State School and Hospital versus Halderman. Okay, and this also tells you that child support is 100% contractual. Okay, Mason standing on count two, her 1983 claim for a violation of her rights under Title 4D turns on whether Title 4D created enforceable rights, privilege, or immunity for Mason. Therefore, if Title 4D did not create any enforceable rights for a person in Mason's position, Mason will lack standing to pursue either counts one or counts two. All right? No one has a right to a service. Okay? I have the right to not sell you any services. McDonald's has a right to not sell you anything. You cannot sue because someone does not want to give you something. An enforceable right is created if the provision in question was intended to benefit the plaintiff. Was Title 4D intended to benefit individual children or women? No, it was not. Look, Title 4D does not create enforceable rights on behalf of needy families with children because they are not the intended beneficiary of the statute. You got no right to it. Okay. Now, the Seventh Circuit has not yet addressed whether Title 4D created an enforceable right for AFDC recipients. All right, this is welfare. All right, AFDC. All right, such as Mason and her children, or whether such recipients were intended beneficiaries of the statute. We know now that they were not. And here it is again. The 11th Circuit has held that Title 4D did not create enforceable rights because it was not enacted for the special benefit of AFDC families. We Hunt versus Ledbetter. That's the one I just read you. Okay. Oops. More recently, the Sixth Circuit reached an opposite conclusion, finding that Title 4D was intended to benefit both the public by reducing welfare costs. Okay. The public, gentlemen and ladies, is not the public in general. The public, if you look it up in Black's laws, means the government. Okay. That is what public means. Okay. It is not the public where people are walking around. No, it means the government. And here it is right here. Look. Oh, come on. Title 4D was intended to benefit what? The public treasury. You have to look at words. This is why you fail. Okay? Now, at least 4 district courts have agreed with Corelli that Title 4D was intended to benefit AFDC families. AFDC families, again, are welfare people. All right? But finding no enforceable rights because no binding obligation on states participating in the program. Nonetheless, Title 4D must also provide unambiguous notice of particular mandatory obligation upon the states to create enforceable rights for Mason. Okay? And here it is again. In this regard, the court agrees in the finding of Oliphant that Title 4D does not clearly require participating states to provide effective, prompt child support services to all AFDC applicants. Illinois, like other states which had voluntarily agreed to participate in the AFDC program, are required to offer for child support services as a condition of receiving federal funding. So number one, the government was created to be a benefit, security, and protection of your rights. That is mandatory. Child support is not mandatory, it's voluntary. Okay, so therefore you don't have a right to it. All right, so total compliance, however, is not required. Okay, full compliance with the regulation in every case is clearly not required. Therefore, there is no clear requirement that every applicant be provided with prompt child support services, and Mason has no enforceable rights to services. In sum, the lack of an enforceable right in Title 4D for FDC families, such as Masons, require the conclusion that Congress neither expressly nor impliedly intended to create a private right of action under that statute, and also did not create rights entitled to protection under the 14th Amendment Due Process Clause and 1983. Mason has failed to show that she has standing to pursue the claims contained either in counts 1 or 2 of her complaint, and the complaint is therefore dismissed in its entirety for lack of subject matter jurisdiction. If you want to learn more, stop by deceptionstoppers.com, schedule an appointment, and we will show you how to shut child support down. Okay? As far as I'm concerned, with all the information that I put out over the years, no one should have a child support case in this country. But it is what it is. So, gentlemen, we are deceptionstoppers.com. I'm Leon Osiris. All right, I have just proved to you beyond a shadow of a doubt that there is no rights to child support, and rights stem from positive law. Child support is not enacted into positive law, and therefore there's no rights to it. And if you read the case laws properly, you will find this out, and you will be able to shut down these corporations which you think are state agencies. Okay? You know where to find me, all right? And guess what? It's on and popping. You want to be free, you know where to come. Hotep.